Hello, everyone. My name is Ariella Wagner. I'm the founder of SunRay Construction Solutions, a national construction document service helping thousands of subcontractors and suppliers secure their lien and bond claim rights. Today, we have another fabulous webinar, a question that is asked all the time, conducted by Alex Barthet. I sent my notice of non-payment or a bond claim. Why won't the surety pay me already? So without further ado, I introduce the fabulous Alex Barthet.
Thanks, Ariella. My name is Alex Barthet. I am a board certified construction attorney here in Florida. And today, as Ariella said, we're going to answer the question, if I sent my notice of non-payment, why won't the surety just pay me already? And we'll break down the requirements that you need to make sure that you secure your rights to get paid. And then I'll explain why the surety hasn't paid you as you were hoping. So we're going to go over the bond claim deadlines so that everyone's on the same page about what they are. Then we'll talk about what happens in the machine that is the surety when they get your notice of non-payment. What are they going to do when they get it or not do? We'll answer the question when they actually will pay you. And if you have any questions, make sure you go ahead and submit them to us right in the GoToMeeting screen on your computer. You'll have the option to submit questions. We'll answer all of your questions at the end. The only thing that I ask is that you don't include any names of people or companies in your questions. But by all means, ask all the questions that you have. We'll answer every one of them in this webinar. So let's go over what the bond claim deadlines are so that everyone understands what the requirements are in order to secure your rights. So step one is to understand that you have to break down bond claim rights into two major categories. Private bonded jobs, that is where an owner or a lender has required that the contractor issue a payment bond. So that could be a condominium, a warehouse. That's the first type. Then we'll go through all of these deadlines, and then we'll talk about private projects, like a school, or a government building. So with respect to private bonded jobs, the general rule is the following. If you have a contract with the bonded prime contractor, meaning you're the plumber. So let's assume you are the plumber on a condominium project and that contractor provided a payment bond. You do not need to send that first notice, that 45-day notice, which is typically called a notice to owner. If you have lien rights, it's also referred to as a notice to contractor on bonded jobs. When you use SunRay, what they do is they use what's called a combined form. So at the top, if you've ever seen that, looked at the form, it says notice to owner / contractor. And what that does is it covers bonded jobs and jobs where you have lien rights. So one form covers them all. Now, if we take my example, you're the plumber to the bonded contractor on this private job. You do not need to send a notice to owner, notice to contractor. And the reason is very simple. The contractor knows you're on the job, so you don't need to notify the contractor that you're on the job. Now, that being said, I strongly, strongly, strongly encourage that you notice all of your jobs timely. Our advice is you set up a process in your office that any job over a certain dollar threshold gets noticed. You don't try to figure out, do I need to notice this job? I don't need to notice that job. You just say, if we have a job and it's over $500, $1,000, $2,500, $10,000, whatever number you decide for your business is appropriate, you have notices sent on every job, no questions asked. I assure you that if you are not implementing that rule and you begin to implement that rule, your collection percentage will go way up. You will do much better at collecting if you just implement that one rule. So if you have a contract with a bonded contractor, you don't need to send the first notice, but you should. So let's move past that and talk about the next deadline. On a private job, you need to send what's called a notice of non-payment or a bond claim notice no later than 90 calendar days from your last work of materials or work on the job. Remember, 90 days is not 3 months. 90 days includes all of the calendar days starting from the day after the last day of work. So let's say I'm a material supplier and I deliver materials to the job site today. Today is my last day of job site deliveries. I start counting my 90 days tomorrow. Tomorrow is day 1. I count every day, weekend and legal holiday, through the 90 days. If the 90th day lands on a day when effectively the court is closed or the mail doesn't run, then I roll it to the next business day. So if my 90th day lands on a Saturday, then I roll it to the Sunday, which then I roll it to the Monday. And if Monday was a legal holiday, then I roll it to the Tuesday. And that's how you count the 90 days for your notice of non-payment. Next, you have to file a lawsuit against the surety no later than 1 year from your last date of either materials to the job site or services to the job site. So these are the general rules if you are working on a private bonded project and you have a direct contract with the bonded contractor. Now, if you are on a private job and your contract is further down, so maybe you're a supplier to a subcontractor, so the supplier to the plumber, you need to now send that notice to owner, notice to contractor, no later than 45 days from your first work of on the project, either first delivery of materials or first work. Now, again, this is the latest deadline for that notice to be received by the contractor and the surety. So you can't send it on the 44th day because it's not going to get there in time by certified mail. You need to send it it needs to be received no later than that 45th day. So if you use SunRay, they use what's called a manifest, where they keep track of all of the mail that goes out every day and they get it stamped by the post office. If they do that by the 40th day, then it's deemed delivered, even if it never actually arrives there at all or on time. So it's very important that you get SunRay copies of your notice requests early so that they can get it to the post office by the 40th day. So step 1 is you have to send that notice to owner no later than 45 days. It's got to be received by no later than 45 days. Step 2, you have to serve that notice of non-payment like we talked about before, no later than 90 days from your last work on the job. You have to file that lawsuit no later than 1 year from your last date of delivery of materials to the job site or work. Now, something to keep in mind that we see folks make mistakes on routinely, and that is that if you are working for a subcontractor, that subcontractor may, because maybe you're the sub or a supplier to the sub, that sub may actually have a bond. And that bond is not recorded in the public record. And you may have rights against that bond. Even, by the way, if you miss some or all of the deadlines that are on this slide right here, you didn't send a notice to owner, you didn't send a notice of non-payment, you didn't file suit within a year. Even if all of those things are true, you may still have rights against the subcontractor's bond. So how do you find out if a sub on your project has a bond? You can ask them. They may not tell you, but you can ask the general contractor if the sub has a bond. That general contractor will have received a copy of the bond and will tell you if the sub is bonded. Now, you may think to yourself, well, there's no way if the contractor doesn't have a bond that the sub will have a bond. And I'm here to tell you that that's not true. It is not common, but it is not uncommon either. I was actually working yesterday for a client who is a subcontractor, fire sprinkler contractor, on a significant job. You know, the fire sprinkler contractor's job is $1 million, his scope of work. And that fire sprinkler contractor has a payment and performance bond on the job, but the general contractor does not. So if you were a sub to that bonded subcontractor, a sub to that bonded sub, or you were supplying materials, you would potentially have lien rights on the project, but additionally, you would have a claim on that sub's payment bond. So if you are either a sub or a supplier to a sub, know that the person that hired you may have a bond, and it's worth checking because that's another place where you may be able to get paid. So let's go over public projects because the rules are slightly different. So if you have a direct contract with the bonded contractor on a public project, you do not need to send a notice to owner. Again, I strongly recommend that you do it, but you don't have to do it. Now, this next fact is going to surprise a lot of people. You actually don't even need to send a notice of non-payment if you are doing work directly with the bonded contractor on a public job. So if I'm the electrician on a public project, so maybe it's a school, Miami-Dade County Public School, and that job is bonded, I don't need to send my first notice, the 45-day notice to owner, and I don't even need to send the contractor a notice of non-payment. Again, you still should do it, but you don't have to in order to preserve your rights. The only requirement that you have is that you have to file a lawsuit on that bond no later than 1 year from your last work or delivery of materials to the job site. And even then, if you're owed just retainage on a public job where you are contracted directly with the bonded contractor, you may still have even more time. Again, I don't think you should wait that long, but again, these are some of the exceptions that exist in the lien law that you should be aware of. So what if you don't have a contract with the bonded contractor? What if you're a sub or a supplier to a sub on a project? So then all of the rules kick in now that you're familiar with. So if I am the supplier to the electrician on a bonded public job, I need to send my notice to owner, notice to contractor no later than 45 days from first work on the job. And I need to send my notice of non-payment no later than 90 days for my last work. And I have to file that lawsuit no later than 1 year. And just like I told you before, on a public job that may be bonded, that sub may in fact also have a bond and is an important place to look. Now, all of the rules I told you are important. Recognize that I highlighted some exceptions to the rules of when you need to send those notices. So keep those in mind. Sometimes if you think maybe I don't have lien rights or bond rights, you may in fact still have lien or bond rights. But let's talk now what happens when you send your claim to the surety. That notice of non-payment only starts the process. So typically what you will, and if you've gone through this process, this will sound familiar. You prepare your notice of non-payment, it's submitted to the surety. The surety then, within several days, sends you a letter acknowledging receipt of your claim and asking you to fill out a proof of claim and provide backup. Know that there is no obligation in Florida to provide a response to that letter or to provide that proof of claim. In most instances, our advice, not every instance, but in most instances, our advice is not to provide that proof of claim. And the reason is that we typically see that providing that information is used by the surety not as a way to pay the claim, but as a way to find ways not to pay the claim. So for example, when you fill out that proof of claim, you'll fill in when your first work was, when your last work was, when you signed a contract, when you sent all the bills. And they may find, oh, look, you needed to have sent a notice to contractor, notice to owner within 45 days. And actually, we didn't get it until the 48th day based on when you wrote in that proof of claim when your first work was. So they may use that as a reason to deny the claim. So we, in most instances, recommend that you do not provide that information. Again, you can, but in our experience, providing that information usually doesn't get you paid. And let me explain why. Most sureties are not willing to pay you unless their principal, the contractor, agrees to pay. So let me reveal to you some of the back and forth that's happening behind the scenes. When you submit your notice of non-payment to the surety typically sends two letters. They send one letter to you acknowledging the claim and asking you to provide backup, the proof of claim. At the same time, they're providing a letter to the contractor. And they say to the contractor, hey, we received this claim. Tell us what you think. And the contractor may write back to them and say, no, we don't agree that they should be paid. We haven't been paid by the owner. There were issues with the work, or they don't respond at all. And the reason that this is interesting is because the surety is not insurance. This surprises a lot of folks when I tell them. Surety bonds are not insurance. When you have a car accident, your insurance company writes a check, usually to resolve the claim, to fix your car, to fix the other people's car, all within the guidelines of the policy. And that is unrelated to your obligations to the insurance company, meaning they're not going to write a check for $30,000 because you totaled the car and then come back to you and say, okay, please pay us $30,000 for the check we just wrote to fix your car that was totaled. That's not how insurance works, but that's how suretyship works, meaning when that surety writes a check to pay your claim, so let's say you're owed $30,000 and they write you a check to pay that claim, they go back to the contractor who they issued that bond for and they say, hey, we had to pay this supplier $30,000. You, contractor, need to pay us back that $30,000. It's an indemnity product, meaning the party that gets the bond issued, the contractor, indemnifies the surety. So they have to pay back the surety for any losses that they suffer. So when I tell you that the surety typically only wants to pay what the principal, the contractor, is willing to pay, it's because that's who they're going to look to get reimbursed. So if the contractor wasn't willing to pay you in the first place, the surety typically is not willing to pay you because that's who they're going to go back and have to get reimbursed from. You need to be careful about any document you receive that shortens your claim period. So there are ways for the contractor to shorten the time that you have to file that lawsuit. I told you that you have a year, but there are documents you can receive that shorten that time. You can get them via certified mail, which is called a Notice of Contest of Liens. And that shortens the time that you have to bring the claim down to 60 days. So be careful about waiting too long, and watch out for the surety waiting you out. I'll tell you a story of a client of ours that got burnt on a claim. They received they weren't paid on a project, so they submitted the notice of non-payment, and then the surety wrote back and asked them to fill out a proof of claim, which they did. They timely submitted that, And the surety wrote back and said, thank you for the information. We'll get back to you. We're going to review the claim. As I told you, you have 1 year from your last work in order to file that lawsuit. Our client, unfortunately, just assumed that the surety was acting in good faith. And what they did is every few months they would ping the surety and say, okay, can you tell us what's going on with the claim and when we're going to get paid? And the surety would have some reason. Well, we reached out to the owner, we talked to the contractor, we'll get back to you. And this went on for months. In fact, it went on for more than a year. And about 13, 14 months after our client's last work, they received a letter from the surety that said, we've concluded our investigation and have determined that the time period for you to bring a claim is now over. So we are rejecting your claim. So what they effectively did is they waited out the claim for the 1 year period. So you have to be very, very careful that you don't ever think that the surety is doing, is trying to get you paid. Always recognize that the surety is trying not to pay you, and then govern yourself accordingly based on the fact that the surety is not your friend. So let's talk about when they will pay you and how you can increase the chance of them paying you. I call it the 60-60 rule. I strongly recommend that you start the lien or bond process, roughly speaking, about 60 days from your last work. Don't wait till the 84th day or 88th day to record a lien or to send a notice of non-payment. From about day 60, at about day 60 from the last day that you did work on the job, that's when you should be saying to yourself, okay, we've got 30 days left. We need to get our lien and or bond claim secured. So that's when you should start to put together all the paperwork, get your lien or bond recorded and served. And then that's the first 60. The next 60 is for the 60 days after you record your lien or serve your notice of non-payment. You should actively work to try to get paid. Hassle your customer, call the surety every other day, call the contractor, send emails, send letters, just really be a thorn in people's side to try to get paid. But if after that 60 days, after you send your notice of non-payment or after you lien, if you still haven't made progress to get paid, that's when you should submit your claim to a construction lawyer for collection. Don't keep waiting. If you haven't been able to make meaningful progress on getting paid 60 days after you lien or send a notice of non-payment, it's not likely that waiting is going to get you paid any faster. The one exception to this is if you have some business reason to wait. Maybe you submitted a notice of non-payment and it's only worth $8,000 and you're doing 4 other jobs with this contractor and everything is going well, and you make a business decision, you know what, we're going to let this one sit because we're doing well on these other ones. I know we're going to get paid. Let's just put this on the back burner. Those are business decisions that you get to make. Just remember that waiting and hoping is not a good collection strategy. Okay, so with that, if you have any questions, please submit them now. If you want more information on construction collections, law, contracts, bonds, and liens, we have a podcast that has an episode that gets released every week. You can find it on the iTunes podcast app, Stitcher, Google Play. We do these webinars once a month for free. You can go to sunraynotice.com/education to sign up for all of them for the rest of the year. The next one is on July 16th, and it's titled, "What form of release must I use when I get or give a check?" And I want to tell you, it's not what you think. We deal with release issues all the time, as does Ariella at SunRay. We're going to go through best and worst practices so that you don't make a mistake when it comes time to actually getting a check, and now you have to deal with the release. Ariella, any questions?
So far, we do not have any questions, but our contact details are on this page. And if you have a question that you think of later in the day or next week, of course, feel free to send us an email or call us at any time. Alex, you did a wonderful job as usual, and I wish everyone a sunny day.
Thanks, Ariella. Have a great day, everybody.